Dukes was a disaster for fairness. It was a godsend for corporations that discriminate. It set the law back and set back the cause of justice in this country. And the goal here is very simply to restore rights and remove barriers that stymie and stop victims of discrimination who seek to assert their rights in the courthouse. The goal is to remove barriers at the courthouse door and enable people who have a common cause of action to come together and save costs not only for themselves but for the justice system. And so the idea of a group action makes sense for everyone who has a stake in the justice system and in anti-discrimination efforts. There should be no dispute about fighting discrimination. And the corporations that may oppose this effort very simply want to bar people from their day in court. Justice Ginsburg had it right. Dukes disqualifies people at the starting gate, at the very place they begin. And that kind of barrier has no place in the American justice system. Group actions ought to be permitted to go forward, and what's more, they ought not to be barred by some standard of proof that requires convincing proof, which is more appropriate for a trial on the merits. We all know, as lawyers who've dealt with class actions, that there is a lower barrier of proof for simply going to the courtroom, and that's the standard that, again, this measure restores. So there's nothing novel or new about this idea. It's worked fine for years until Dukes, and simply restoring worker rights to fight discrimination is absolutely essential now as a matter of simple justice. Rights unenforced make no difference. Rights depend on enforcement to be real. And this measure simply enables people to enforce rights that they have under the law in a way that makes sense in dollars and in fairness.
It is a privilege as well as an honor for me to be with all of you this afternoon. And I would like to start off by saying good afternoon. Good afternoon. And I am Betty Dukes, and I'm in Washington to mark the first anniversary of the Supreme Court's ruling in the Walmart versus Duke decision. I came today to spearhead a rally, and the purpose of this rally was to let the American workers know and my co-workers that our fight is not over. A year has come and gone since they released their ruling, and quite a bit has happened in the meantime. A lot of class action suits that was on the book has been overturned based on that egregious ruling from the Supreme Court. We have to do something about it for present generation as well as future. I brought the discrimination lawsuit against Walmart more than a decade ago with the expectation that American women like myself and the 1.5 million of Walmart would have our day in court. We want to go to court because we are seeking justice and fairness. That day has yet to come. 10 years later, 10 years plus later, we're still laboring to get into our justice system and our case be heard. As you know, when the Supreme Court ruled a year ago, they did not rule on the merits of our case, and we still believe that they are as strong today as they was over 10 years ago. We are still determined to have our day in court. Not only was the Supreme Court decision denying national class action status in the Dukes versus Walmart, a devastating blow did go out to the women of Walmart and undermines more than 4 decades of employment protection for all American workers. I believe our civil rights I believe our civil rights are only as valuable as the means exist to protect them. By making it much harder to bring civil rights class action, the Supreme Court weakened our rights to protect against sex discrimination. They did more than weaken it. Their decision virtually destroyed it. There is a difference. We have practically nothing to stand on now. It is critical for all of us, and especially those in position of political power, to fight for the rights of workers who now have no safety net, to protect them against the increasingly unfair labor practice. We need to pass strong legislation that will reverse the damage done by the Supreme Court and restore the civil rights of everyday workers. The Equal Opportunity Employment Restoration Act is an important step in that direction. We will press on with our case against Walmart, for our resolve is yet strong. We will press on for ourselves and for the women who have worked there and continue to work there, as myself. Despite the roadblock that the Supreme Court has erected, our fight truly is not over. We continue to seek justice in Dukes versus Walmart in California, Stephanie Old versus Walmart in Texas, and in a dozen or more similar cases that are scheduled to be filed around the U.S. this year, and nearly 2,000 independent charges that have been filed against Walmart with the Equal Employment Opportunity Commission in 48 states. The Supreme Court did not rule on the merits of our case. That is yet to be resolved. But there is no doubt in my mind that last year's decision has made it much easier for companies like Walmart to avoid accountability for their unlawful acts and discriminatory behavior. I urge the passage of the Equal Opportunity Employment Restoration Act to the right that was wrong. Thank you. Have a blessed day.